are watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, you shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. This morning I want to extend a special word of welcome to the educators from around the state of Florida who are here at the court this week participating in the Justice Teaching Institute. We're very glad that you're able to be here for this oral argument this morning. The first case on our docket is Smallwood versus the state of Florida. Actually, the only case on our docket.
May it please the court. Good morning. I'm Barbara Basheras, representing Cedric Smallwood, who asks this court to find that the police exceeded the permissible scope of a search incident to arrest
I'm sorry, could you just speak up just a little bit?
Yes, I'm
right
sorry,
into
Your
the
Honor.
mic.
Is that better?
Yeah.
Okay. Yes. He asks this court to find that the police exceeded the scope of a search incident to arrest when the officer who arrested him opened his cell phone and looked at personal photos that were stored there without having any other justification for doing it than it was in his pocket at the time of his arrest. Can we
tell from this record when the police actually looked at his cell phone? I know they told the prosecutor was over a year later, so when did the police actually search the cell phone?
Your Honor, the police searched the cell phone at the time of his arrest. The officer who arrested him testified that he met Mr. Smallwood at a fast food restaurant, put him in handcuffs, escorted him to his car, and then patted him down before placing him in the car, at which point...
Is that undisputed? That is, that at the time that he took the cell phone, that the defendant was in handcuffs?
Yes, Your Honor.
And I know that in the brief you say that they met at Popeyes and then he gave him his arrest warrant and handcuffed him. Is there anything in the record about what had preceded that? In other words, he obviously the police officer was gathering facts to get the arrest warrant, but how they picked, rather than going to his home or asking him to come down to the police station, why going to a restaurant was what the officer arranged?
It's not completely clear, but it is clear in the record that the officer identified Mr. Smallwood as a suspect. He testified, I believe, that he went to Mr. Smallwood's mother's house.
But I guess what and maybe it shouldn't matter whether this was an arrest warrant, whether it was, should the circumstances to whether he asked Mr. Smallwood to come to the police station or whether he went to his house to serve the warrant or picked an open, a public place matter in terms of the search. And if it doesn't, then my questions are not relevant. But to me, I sort of was startled by thinking of the meeting in this Popeyes and then saying, hey, you're under arrest, handcuffing him, and then taking his phone and then looking at it.
What the record indicates, Your Honor, is that after going to the home that he knew was connected to Mr. Smallwood and not finding him there, that there were phone calls between the arresting officer and Mr. Smallwood. It's not clear who suggested the Popeyes, whether it was the officer or whether it was Mr. Smallwood himself who said, I'll meet you at Popeyes. That's not completely clear.
So Ms. Smallwood knew he was going to be coming to discuss this crime?
Yes, Your Honor. It wasn't just a chance meeting, oh, I'm in Popeyes for lunch, I see somebody that I know has an arrest warrant. It was a consensual, in a sense, meeting where Mr. Smallwood had agreed to be there ahead of time.
What does that, how does that impact, in your view, if any, the legal issue with regard to whether you're in Popeyes or whether there's an encounter on the street or in the city park?
For our position, Your Honor, it doesn't impact the analysis. What it might impact in the larger scheme of things is that if this is not, as we contend, a search incident to arrest or a proper search incident to arrest, there might still be other circumstances in other cases that would have allowed the cell phone to be looked into, for example, exigent circumstances in the right case. But this was not a situation where any other circumstances were present. There was not an ongoing crime or a situation of danger or the imminent destruction of evidence that the police would fear. There was simply a prearranged meeting some weeks after the crime had taken place.
And you're not contesting that they had a right to take the phone?
Yes.
It's really not the seizure of the phone. It's the search of what was in the phone.
Correct, Your Honor. We haven't contested the seizure itself.
Can we tell from this record what type of phone this was? Was it a smartphone, like an iPhone, or was it just a cheap cell phone?
That is not in the record. What we know is that it's a phone that had the capability to take and store pictures, but we don't know its internet capabilities.
I have an iPhone, and I know how to turn it on. That's about it. Are there other phones that can take pictures that are not smartphones?
Yes.
That are not programmable?
Yes.
Okay.
Now, do you concede that if the police had found a notebook, moleskin notebook, whatever kind of notebook, in the defendant's pocket, and they had looked at it, and they had paged through it to see what they might find, that would be legal?
There is precedent allowing searches of notebooks or folded pieces of paper or that type of thing that are found in a pocket. Yes, Your Honor.
Or an envelope that had photographs in it would be the same principle, right?
An unsealed envelope containing photographs that could simply be opened and the physical photograph seen. I believe there's precedent allowing that as well.
Well, I think I understand your argument. It's about technology. But in principle, I mean, it may be a question of the amount of data, but the data in a notebook could be as incriminating or as personal and as much something that someone would want to keep private as what might appear on a phone. Isn't that correct?
Absolutely, Your Honor. The question is not just technology, though, but reasonableness.
Well, but don't you run up against the categorical rule that the court stated in Robinson? Because they said we're not going to get in to the reasonableness of what they're looking for when they arrest someone, when the police arrest someone, they specifically rejected applying a Terry-like standard, which the appeals court there had done, and stated a categorical rule that unless I'm misreading it, a categorical rule that if the arrest is legal, then they can search the person of the defendant, and what they find is part of that search. Isn't that correct?
Robinson did say that as a rule. I believe you have to see that in light of two things. One is the context of Robinson, which was deciding whether the officer had to stop at simply patting down the defendant at that time, or whether a full search of the person could be conducted. Robinson really was not addressing head-on the type of issue where somebody would have so much personal information on them that it might exceed, the search might exceed the scope of what's reasonable.
But the whole rationale, it seems to me, for Robinson is based on this categorical broad rule that if someone is legally arrested, they are subject to a full custodial search. That's just part of what goes with being arrested, not just to protect the officer's safety, but to look for evidence. Isn't that correct?
Correct. And based on, I'm sorry, Your Honor?
I guess your argument is more akin to the findings in Arizona versus Gant, the United States Supreme Court decision of 2009, and there they arrested the accused and actually handcuffed them. And after that, after he was secured and handcuffed, the police went into the back seat of his car and found a jacket, and of course searched the jacket. Inside the jacket found the contraband. The Supreme Court basically said that once he was handcuffed and secured, then the exigent circumstance of the accused possibly destroying the evidence, reaching into it and destroying it, was gone. And at that point, the police was required to get a search warrant to go into that jacket. Now here, if I follow your argument, what you're saying is that once the police had possession of the cell phone, any possibility of the defendant reaching it and destroying it was gone, and the police had a duty at that time to get a search warrant. Now, obviously, later on, the prosecutor did that, but the police did not at the time that they secured the information.
Correct.
At the time of the arrest.
And I think the record indicates that the only reason the prosecutor looked on the phone as well was that the policeman who had seen these images said, hey, by the way, there are things on the phone you want to see on the eve of trial.
Well, going back to what the scenario that I just painted for you, and the reason I asked about the cell phone business is that with technology, the way technology is advancing with cell phones, is it possible? And again, there's no factual basis for this in this case, but is it possible that a cell phone can be completely wiped clean remotely from another computer?
It's not in the record of this case. That possibility does exist for cell phones, certain cell phones, as well as certain laptops.
So there may be a case in the future where there may be an exigent circumstance, in the sense that while the police goes out to get a search warrant, that person's partners in crime may be wiping the phone off completely clean.
But, Your Honor, those phones and those laptops have to be connected to the Internet for the wiping clean to happen. And so I would concede in that circumstance that there might be a reason to manipulate the phone enough to turn it off so that it can't be connected to the Internet and the information can't be lost.
Here is my question. I want to go back to United States versus Robinson, because that seems to be the primary case. If there is a categorical rule, is the rule then, and it's the search of the person, the question then is, once there's the search, does the Fourth Amendment still come into play as to whether there would be a reasonable expectation of privacy in what is contained and what is seized? And I'm asking you that because, again, and Justice Labarge is giving some other examples. I've thought of, a flash drive, a CD, an iPad, a digital camera. Does that matter as to what it is that's taken at the time of the search, as to whether police then can just go and look in it without getting a search warrant, which is all I think you were needed to be done to see if it is there's probable cause to believe that they're like reasonable probable cause.
Right. The probable cause would precede the warrant, and then they could look at
to
what
see
the contents
whether
of the
there might
storage device.
Evidence related to the crime. That would be the standard, correct?
Correct. The problem with Robinson, and going back to what the Chief Justice was asking about earlier, is that the changes in technology have put reasonableness on a collision course in these cases. When Robinson was decided, mobile phones were the size of a suitcase. Almost no one had them. Computers were the size of this council table. The idea that we would all be able to walk around with these storage devices that contain our entire personal library or photo albums.
But I guess what I'm asking is, why should that, are we bound, if we're bound by Robinson, then the fact that this court might think it's time to change Robinson, we're bound by the Fourth Amendment construction that the United States Supreme Court has enunciated. And isn't this more like Robinson than it is like Arizona versus Gantt?
No, Your Honor. It is more like Arizona versus Gantt.
Didn't Arizona versus Gantt have to do with the search of the vehicle, not the search of the person?
It did, but it had to do with the twin underpinnings.
That seemed to be a pretty material distinction.
No, not in this case, Your Honor, because at the time Robinson was decided, we're really not asking that you ignore Robinson. We're asking that you not extend Robinson to cover a set of personal effects that couldn't have been envisioned at the time Robinson was decided.
But I guess why does that matter if the rule is if it's a categorical rule, that you get to search anything that is on the person of the defendant, and there's no question the cell phone is on the person, not, that he didn't come and his computer was left on the table, is on the person, and the search, then what's the next step? Is that they say, well, then you can also search whatever is in that object. Here, and so where is it that Robinson's categorical rule is not applicable?
Because of the fundamental reasonableness requirement of the Fourth Amendment, Your Honor, that it's simply not reasonable to expose people to that degree of potential intrusion that electronic devices create simply because they've been arrested, potentially for something as minor as a traffic violation. It's simply not reasonable to allow unfettered access to somebody's electronic storage media because we've developed these devices that are small enough to be put in a pocket. And, laptop computers are now small enough to be put in a pocket.
But doesn't that require a revisiting of the rationale of Robinson? Because Robinson specifically says that once you have the lawful arrest, that the full custodial search, they say a lawful custodial arrest, a full search of the person is not only an exception to the warrant requirement of the Fourth Amendment, but is also a reasonable search under that amendment. They've made that categorical statement.
And which would be why the location and the seizure of the cell phone itself would be reasonable, because if it is on your person, you can't say, don't touch that. It's a cell phone, or don't touch that, it's my laptop. But to go beyond that, given the breadth and the variety of information, personal information that people now store on these devices, exceeds the scope of what is reasonable. This court recognized in Jenkins, a case involving a search incident to arrest, that a search incident to arrest still has to be reasonable. And when you are looking...
Didn't Jenkins have to do really with the manner of the search? I mean, there was a question of a strip search or rearranging someone's clothes out in a public place. And,
correct, Your Honor. But the manner is how it was determined that the search was a reasonable search. The foundational principle that has to be addressed is still, was this a reasonable search? Because it was unquestioned in that case as well that at the time that defendant was arrested, that a full search of the person would have been permissible. The question was, how far does a full search of the person person extend. We're saying here a full search of the person does not extend to going inside electronic storage devices that technology has made available.
Counsel, you have asked to reserve 5 minutes. You're eating into your 5 minutes.
I am. Thank you.
May it please the Court, Christine Gard on behalf of the state of Florida. The United States versus Robinson explicitly permits the search of the cell phone in this case because it was a search incident to a lawful arrest. And
certainly principles of law are developed from the facts presented to the court. You would agree with that? Certainly.
Yes, Your Honor.
And can you explain to us how, in drawing legal analogies, we should consider a crumpled, empty pack of cigarettes that are all crumpled, having contraband inside them, equate with modern technology that clearly is designed to hold, stores of evidence?
Our Fourth Amendment and certain other areas of law are developed based upon a set of rules that can apply over a wide range of circumstances. So as technology evolves, those rules still apply to. In this particular case, the per se rule from Robinson is that anything found on the person or in their hands versus a grab area search, which is a separate set, that's a Gantt search, on the person is per se reasonable, and we do not, under the explicit instruction of the United States Supreme Court, look at the factual circumstances surrounding that. As long as it's found on the person, we don't go back and have the courts redetermine later whether or not there was probable cause, and that's in the express language in Robinson.
So this would be far more expansive than just a telephone. If I'm holding clearly a laptop computer, they can not only take possession of that computer, but they can take that and go to any extent and search each and every part of that computer then.
That's certainly not the facts presented here, and there is...
I'm saying that's what the result is under your argument, though.
Yes, Your Honor, because it is a per se rule.
But isn't there actually, as you say that, there is another, and I appreciate what you're saying about Robinson, but the Robinson court really went at great length to talk about the two reasons that you would search incident to an arrest, one being the protection for officer safety, and the other being to prevent the destruction of evidence. And in this case, we have no question that the officer, Mr. Smallwood, was already handcuffed, so there was no issue of officer safety, and nobody is saying that they couldn't take the cell phone. But the other part of this that concerns me, because I think what you would be saying would extend if it was a flash drive, for example. What if Mr. Smallwood was a student who was doing his PhD thesis, and the only part of his thesis was on a flash drive, and that by opening it up and seeing what's on there, that the officer inadvertently, wiped his whole thesis out? I mean, there's other issues just to be looking at here as to whether the invasion of privacy, which necessarily is occurring incident to an arrest, is reasonable or needs to be looked at by a detached magistrate, which is the whole idea of the Fourth Amendment. So does it end any place as far as what officers can do when they arrest somebody? Is it just anything that's on, and they can look at anything that's in there?
Your Honor, I would suggest password protecting your items. They certainly can't force that out of your mouth, the password itself. Now, whether they can get around it some other way or not, I don't know, and that's certainly not the case before us today.
Is there any other Fourth Amendment law that says our citizens must place certain types of locks on their homes so that law enforcement cannot enter and violate the Fourth Amendment? That's what you seem to be saying, is that the obligation is on the citizen to somehow place something on the technology or the technological device that will keep the police out. Is there any law that supports a Fourth Amendment requirement on our citizens to do that?
Your Honor, respectfully, a home is entirely different from a search incident.
Respectfully, I think technology is entirely different than a crumpled pack of cigarettes. So we can respectfully disagree. My question was, getting back to, is there any case law that places the burden on the citizen to do something that will stop the police from violating the Fourth Amendment. That's the argument you're making.
Respectfully, Your Honor, we do. If you want your curtilage protected, you enclose it. Now, that doesn't mean they can come in your house, but that's how you prevent the officers from getting to your curtilage.
Well, it seems then you're really saying that the right to look at what is on the cell phone is not incident to an arrest, is not unlimited. So it isn't like photographs that you might be carrying of your grandchildren, and then you just happen to have some other photographs that you didn't really think anyone was going to look at, and now they're looking at it. You're saying that if Mr. Smallwood wanted to protect his privacy of the information that was on his phone, or any citizen that might be stopped, for a traffic offense and then arrested, that they would have to password protect their phone in order to ensure that their privacy is protected. Is that the rule of law that we would be announcing here?
No, Your Honor, I don't. Respectfully, the password protection issue is not before you. It has not been briefed by the parties. And if you
raised it.
Respectfully, in response to your question, Your Honor. But what I will say is that there is case law that says, for instance, in Belton, that you can get into both locked and unlocked containers.
But so not after you separate. Belton is very clearly limited. Gant says once you separate the individual from that vehicle, you can no longer do that.
Yes, Your Honor. There are respectfully two types of searches incident to arrest. And Robinson carefully delineates the two different types of searches. There's the search of your person, which...
Well, you were just relying on Belton.
I just referenced Belton.
Belton is a motor vehicle, is it not?
It is, Your Honor.
All right.
But what I was indicating to you is that it's not a clear precept of law. There isn't a case that says if you password protect your cell phone, then it's automatically protected. And there's not a case that says if you don't password protect your cell phone, it's automatically not protected. United States versus Robinson.
That's not before us, really. And you're certainly not conceding that a password protection would preclude the state from getting into it.
No, I would certainly suggest it would make it harder, and that is all I can suggest at this time.
My concern, again, we begin in the search and seizure area of the law. We begin with the proposition that the Constitution requires a warrant for any search, except in areas that we had carved out an exception. Here we're dealing with a search incident to an arrest. And that's permitted as an exception to the warrant requirement for two reasons. One, protection of the officer, and two, to protect the integrity of the evidence. What you seem to be saying is that once the officer searches the person and finds a piece of evidence, the objective is no longer to just protect the evidence, but once you have it, you can go fishing to see what else exists. That's what I'm having trouble with here, because they had possession of the cell phone, so the evidence they found on the person was protected. So that goal was met. But what you're saying is, well, once we have it, we can go ahead and look at it to see what other evidence we find. I don't know that Robinson, and certainly Gant, permitted the police to go fishing for more evidence once they take possession of the property.
Respectfully, that's exactly what happened in Robinson, Your Honor. They went fishing to see what was in the cigarette package that was closed and crumpled and could not be seen without opening it. That is precisely what happened in that case. And as a result, when you have a search incident of the person incident to arrest, you have an entirely different set of circumstances or of case law that applies. And Robinson recognizes that until Robinson, the premise that everything on you could be searched, incident to arrest, was virtually unchallenged. But when you got to the other area of the law, these automobile-type, Gantt-type cases, the grab area cases, the what's around the Chimmel-type cases, what's around your home and around your immediate surroundings, that law was constantly essentially evolving. You had Chimmel, and then you had a series of other cases.
So let me ask you this. If this had been an arrest and say he was in a vehicle, the defendant was in a vehicle, and he was taken out of the vehicle and arrested, and the cell phone was actually on the seat of the car, would the police then be able to search it without warrant?
Not unless there was a different exception that applied.
Okay. So in a search incident to arrest, it's clear they could not do that cell phone if he were arrested on a car.
Yes, under Gant.
So the difference here is they took it from his person.
Yes.
And that therefore under Robinson, the police was free to search it.
Yes, and that's why there's two different lines of cases
But doesn't it strike you, even when saying that if the two reasons are officer safety, which no one is contesting is a overriding concern, and especially, when there's no arrest warrant and some officer is just making an arrest, that's not the issue. And then the second is evidence that might be destroyed. Second issue. As a officer of the court, as representing the state, given what Justice Quinn says, how does it make sense, subsequent to Arizona versus Gant, to talk about the scope of what gets searched once the suspect is secured, and there is no danger to the officer, and there's no danger of destruction, between whether the object remained on the person, or say here, Mr. Smallwood had put his phone and put it on the table where he was talking to the officer, which then, under your circumstance, would be they couldn't do anything with it because it was on the table. Where is the Fourth Amendment distinction that could be explained?
The Fourth Amendment distinction is simply what exists. There's two different types of searches.
So you're saying that if Mr. Smallwood, again, I'm sort of imagining this Popeye, getting together, and I don't know if they ordered, some chicken first or whatever you do there, and he's talking to him, and Mr. Smallwood gets a call, still the arrest hasn't occurred, and he gets a call, answers the phone, hey, yeah, I'll be picking up dinner in a few minutes, puts the phone down, and then he arrests Mr. Smallwood. What's he able to do with the phone?
Well, I think it depends on whether he's been removed from the situation. He can certainly seize the phone, but whether or not he can, because he has to pick it up. He has to take it with the defendant. It's the same as an inventory search. If he left it in his car,
So once he handcuffed him, though, and the phone is still on the desk, he can't do anything with it.
That appears to be the case out of Gant. But what I will say is, in this particular case, this court would still have to affirm in this particular case, because we know that Gant is not applicable to pre-Gant searches, and this is a pre-Gant search. So the United States versus Davis, or Davis versus the United States, out of the Supreme Court has commanded that result, that it meets the United States versus Leon requirements.
On this because now you're talking about good faith, I have, and maybe it doesn't matter, but this is a strange case to me, because the officer either didn't think that the pictures he looked at, I don't know whether he didn't think about it, they weren't in his arrest report, certainly, and then a year later, when the state attorney finds out, the state attorney realizes, or assistant state attorney, I better get a search warrant. And it is like the objective view of the representative of the state thinks, I can't just look at this phone that was seized. I need a neutral officer, a magistrate, to make sure that I can link up what is on this phone with that it might be related to the crime. It's a fact in the case. It may be as irrelevant as Popeyes, but it's just sort of, what would you say about that?
I would respectfully suggest it goes with Popeyes, Your Honor. Here, we have a couple of things going on with the prosecutor. Number one, he gets surprised by this. The better practice is to get a warrant. If you can get a warrant, get a warrant. If you don't, there may be a reason why you don't have to get a warrant, but he got a warrant. And we also have a long time lapse between the time that the officer, I think I've forgotten how long it took for this case to get to trial, but it certainly wasn't next Tuesday after he was arrested that he went to trial, so there had been a time lapse. You have to, I don't know that our prosecutor reached the case law to see that he could still look at it because it was held, and and all that kind of thing. So he engaged in what would be a better practice. But the fact of having a better practice or a worse practice is not the issue of law.
Let me ask you this. Aren't there some of these phones, don't you have to have some kind of code to open some of the phones?
Yes, Your Honor.
Okay. And so if this had been that kind of phone, what would the police officer have been able, could they have forced him to give him the code to the phone?
I respectfully suggest that this court's case law would preclude such a thing. If we can't force you to say your ABCs in a DUI stop, then I would suggest you can't force someone to get
even
the
if the police have probable cause, I guess that you can have hackers, I guess, who could open it up if there was probable cause to open it, I suppose. I'm just wondering how a phone that is secure and you can't get in it without some kind of code is different from, like the flip phone that I have, that, you just open it and go from there.
And I can't answer that question. It's certainly not on the facts before the court. And it does involve technology. We have cited a case that does indicate that these phones are easily wiped clean. I provided the court with a law review article on that, as it seems to have become an issue.
But who could do that?
We could
consult. If you have a phone that can be wiped clean, I think your opponent says basically that you've got to be hooked up to something, the internet, or I guess another computer or something to do that.
Well, let's use Justice LaVarga's iPhone as an example. When you turn on your iPhone, there are a number of steps you have to go through to get to the settings button to then go ahead and turn off the internet capability or to turn it back on, so there's a whole number of steps you'd have to go through. So you'd have to actually get into the phone in the first instance to turn it off, to turn off the internet access so that you could then turn the phone off. And in Faudree, for instance, we would already be to the evidence.
Let me go back to your position on the scope of the officer's ability to search the phone. I learned yesterday about this thing called iCloud. You heard of that? It is external storage that people rent, and is kept on some mainframe someplace. It's for people who need to store a lot of things. Once you get a cell phone and you have possession of the cell phone, under your interpretation, could the police actually go into the iCloud and see what's hidden there?
Again, Your Honor, I don't know the intricacies of the iCloud formulation and how one accesses iCloud, so I can't answer that question. If your iCloud requires a separate account to get into it, like my Bank of America Online requires, I have to input my password, my username, and all that, so even though I have the app on my phone.
Let's assume for a second that if you have possession of the cell phone, that you can connect with iCloud and find out what's in there. The mere possession of the phone after obtaining it legally in a search pursuant to an arrest, would that, under your interpretation of law, permit the police to look in, assuming they can just open the phone and push a button and get to iCloud, could they look in there?
Your Honor, I can't answer that question respectfully. I don't know enough, and it's certainly not the facts of this case, and I'll be happy to prepare a supplemental brief on the issue.
You can understand the scope of our opinion, how far-reaching with technology it could be.
I do understand that, Your Honor, and respectfully, when that case came to this court, that would be the time to delimit it when you have those facts.
But really, you're not, this is the case, because what you're saying is, if it's not password protected, that once the phone is seized, that law enforcement without a warrant can look at anything on the phone. And I mean, since most of us know about iPhones, you know that all your email can be on there, all of, photographs, videos, and so there is really no limit to what then at the time of seizure the police could look at without a warrant. And again, I go back to the jump drive, which is never password protected, to see everything that is on a person's jump drive. It's because there's no difference under your scenario between a jump drive, a smartphone, a dumb phone, a small computer.
A jump drive can be encrypted. and therefore it could be password protected. But moving.
Okay, so I stand corrected there. Why am I arguing with someone who is probably 40 years younger than me and knows much more about technology? Sorry.
That being said, again, it's what you permit there to be access on your phone, too. Now, for instance, since we're talking about iPhones and iPads, I can shut down my email access on my iPhone by simply requiring my login and password to be entered in order to enter my email account, just like on my office computer.
Well, but isn't there a distinction, I mean, pretty obvious distinction, between information that is actually on the phone as opposed to information that is located remotely that might be accessed through the phone?
Right, and when I leave my Yahoo emails on my phone.
And what we're dealing with here is information that is on the phone.
Correct.
As opposed to information that might be accessed remotely through the phone.
And I would suggest that the access, like the iCloud access, is better left for another day when we have someone who knows about the technology and we have a record developed that can explain to us how all that technology works, and then maybe we're in a different search area. Maybe we are truly now entering a house or something else versus being on a phone C search incident to arrest. With that, the state asks that you affirm the judgment and sentence in this case, and just in passing reminds you that this search, because even if you did resort to Gantt, would have to be determined to be reasonable. Thank you.
Although the constitutional issues are fascinating, is there a issue that this was harmless in this case?
No, Your Honor. There's really no issue of harmlessness.
Well, there's an issue. I mean, it's raised.
There's always an issue of harmlessness. The record doesn't support that, though. The record indicates that even the trial judge was sort of shocked by the photos and indicated that he was surprised the jury took any time at all to deliberate after seeing them. Also, if you look at what was in the photos provided a connection that the rest of the evidence didn't. Mr. Smallwood was never seen without a mask at the scene of the robbery. He was identified by his voice as a suspect. The photo of the gun on the phone was the only link between him and the weapon allegedly used in the robbery, because the gun itself was never located.
Here's another question on the facts of this case, because if this goes on reasonable expectation of privacy, that you're saying distinguishes this case from United States versus Robinson, and maybe it goes back to my first question. Police says Mr. Smallwood knows he's going to meet the police to discuss his participation or lack of participation in a crime. He comes with his cell phone. Doesn't he, what expectation of privacy would he have in what he brings with him? What if he had just printed out all the photographs of the crime and had them, as Justice Kennedy was saying earlier, in a packet, just said, hey, I think I'm coming here, and he might as well see really what I did. I mean, isn't there some level at which he knew what he was walking into?
Your Honor, the cell phone has become so ubiquitous in use in this country that I would say that it's very dangerous to consider it a waiver of the expectation of privacy.
Well, how is it any different? What if he came with the money that he had stolen, or I don't know what else he took from it? I mean, he came with evidence of the crime he committed.
The physical money could be seen without delving further into the packet of money. The phone, the pictures on the phone couldn't be seen without going into the phone and seeing other things that the officers had no business seeing, had no reason to want to see.
What is your response? You just heard the discussion and exchange with regard to evidence that may be on the phone or evidence that may be remotely accessed.
I certainly agree that the record here doesn't get us into the territory where we're in the iCloud. That this is talking about evidence that was found stored on this phone. Mm-hmm. But I would still say that the storage capabilities, the variety of information that can be stored on a phone, take it out of the category of things that can be considered part of your person for purposes of the Fourth Amendment.
Is that the same analysis if we're talking about a phone where I have a personal email address that has nothing to do with the phone itself, but I can access that email from the phone. And so that email isn't actually stored on the phone, but I can get to it. So is there any difference there?
Your Honor, one danger would be that if you have your email open at the moment of arrest, it wouldn't matter whether or not it was password protected or whether it was stored somewhere else. The police could still see whatever
once the
was
officer has your cell phone, and he can then go into any email addresses that might be stored there or anything.
That's the danger. And the cell phone may be a portal for access to other locations, but it can also tell you what those other locations are. So the fact that you can't get into the cloud doesn't mean that you couldn't see on the phone where somebody has gone using that phone,
clear off my phone.
Which again is just too wide an intrusion into people's personal information to be reasonable under the Fourth Amendment.
How do you see your opponent says, well, okay, so if you're right under a Gantt theory, this actually occurred in 2008. Gantt's a 2009 case, and Davis says, if the law was clear, was the law clear?
The law was clear as it related to, actually I wouldn't say it was clear. If it was clear, they wouldn't have needed to come up with Gantt to solve some of the confusion. But there was a long-standing precedent involving automobile searches, that the police could go into an automobile. And the cases that you're talking about, the good faith exception cases, all involve police conducting similar types of searches who had been trained. These are okay. As the state has pointed out, this is not the search of an automobile.
But if they say this is the Robinson scenario, and so so even if this is wrong, they're relying on Robinson, so therefore this is not suppressed.
The answer to that is two-part, Your Honor. First, Robinson simply shouldn't be extended that far, which is what we've been saying. The search incident to arrest rule of Robinson that encompasses physical objects that can be seen at the time of the search doesn't include going into an electronic storage device, whether it's a camera, a computer,
so
or a
your
laptop.
Point is, you're saying that the law was not clear. There's not a large body of law like there was under motor vehicle searches, so therefore nothing to rely on.
And in fact, that's been recognized in at least two cases under Section 1983, one of which was in the supplemental authority that I filed with the court, that there is no settled precedent in this area. And so for that reason, there can be no good faith reliance on the settled precedent to look at the cell phone. If there are no further questions, thank you, Your Honors. We ask that you reverse.
We thank you both for your arguments. That concludes today's session. The court is adjourned.
All rise.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU TV,